My name is Liz. Good call there. Welcome, everyone. My name is Liz Keegan. I'm the Director of Education and Outreach for the Fair Housing Center of West Michigan. And with me today is Bree Miranda, our Education and Outreach Coordinator. And behind the scenes, we have Lindsay Owens, also an Education and Outreach Coordinator, and Sarah on our team helping us as we provide this wonderful training. We're really excited to focus on accommodations, modifications, and most importantly, assistance animals today. This is sponsored under a generous grant from the Michigan State Housing Development Authority, or MISHDA. We'll take a look at some housekeeping issues here as we continue to welcome folks and get them online. So as we put in the chat, we are taking attendance through a mandatory survey. Each individual must complete the survey. I know some of you may be watching together in groups, which is totally fine, but you all need to make sure that you individually fill out the survey. The link will be provided at the end of the class. It should also open in your browser as you're logged in here as well. So make sure you copy that link and fill the survey out before the end of the day tomorrow at 5 o'clock, please. This is how we can ensure attendance and also, probably most importantly, generate accurate training certificates for you, which will be sent out in the mail in a few weeks. As I said, we've had a huge response to this class, so it'll take us a little while to turn around and generate those certificates. But most importantly, we need each individual person to fill out the evaluation and survey, provide your name, how you'd like it to be listed on the certificate, and your mailing address. We are not able to hear you or see you, but we can use the chat to communicate. You can send a message to the host and panelists directly, or you can use the chat to share something with everyone. We also will take questions in the Q&A feature throughout the class. We may stop and address it if it's timely. Otherwise, we will also save a chunk of time at the end of the class to answer questions and circle back, as we know this is a very hot topic. The session is going to be recorded and will be made available to all attendees and registrants. We will post the link and share that out within a week or so. You'll be able to watch the class online. You also should have received an email with a lot of handouts. We know it's a lot of information, but we have some great tools that we're really pleased to share. And so that email went out yesterday and today. So if you didn't get that, please let us know, and we will make sure to forward that information to you. As we mentioned, the evaluations must be completed individually. You should have a tab open in your internet browser with the evaluation, and we'll provide the link at the end. And once again, special thanks to MISHDA, who's putting forward some fabulous grant funding for all of the Michigan Fair Housing Centers to provide trainings. We've got a whole list of future dates, and we can also connect you to other fair housing centers closer to where you are. We had folks from all over Michigan and few other outside states signing in to join us. So we're really happy to welcome you all and to continue to see the numbers click up. So thanks for letting us know. We have one request for the handouts there in the chat, so we'll follow up on that.
And I wanted to add, I do see a couple people are calling in via their cell phone. If you could please send us an email with your phone number that you attended with, so that we can get you any documents that you need. If you need the survey link, you can email us and let us know. Zoom doesn't provide us any information other than that you're calling in from a phone number. So if you can just email us and we can forward you the survey link.
Absolutely.
And then here is our contact information for everyone. As Liz said, I'm Bree Miranda. She's Liz Keegan. And then those are our emails. And in the handouts, you should be able to click those to contact us directly.
Absolutely. And then we have a great question in the chat. If you have people watching in a group, each of you should be able to use the same link to take separate surveys. So thank you. That's an important question, but we've enabled the survey to allow multiple people to take it. And so you all should be able to use the link, and you should get a confirmation page once you have successfully filled out the evaluation and the survey. So thanks for that. That's a great question.
And then our agenda today, we will do a poll to kind of get to know you. We will do a brief overview of some fair housing laws and protections, just very briefly, just go through them quickly, go over some state of housing discrimination, and then we'll get into the meat of the presentation, talk about reasonable modifications, accommodations, assistance animals, and some tools.
Excellent.
So the first poll here is, I'm going to launch it now. Do you have, oh, sorry, that is the wrong poll.
One of those
Sorry.
Zoom things where they change up a feature on us and we have to relearn it.
Sorry about that. Okay, this is the right poll. Do you have experience with reasonable accommodations or modification requests? Yes, no, and I'm not sure. We'll give about 30 seconds to a minute here, and then if you're watching in a group, you'll have to do the majority rules.
Come to a consensus and place your vote. These are all anonymous. We don't use the polls as any sort of grading or test taking. It's just a way to help us learn. I see a lot of familiar names on the call, so I really appreciate you all adding to your fair housing expertise, but we know there are new folks as well, so it's helpful to hear the range of experience from all of you. So, for those of you who have just joined us, we will be taking attendance through a separate link. So I appreciate you providing information in the chat, but it's mandatory that each individual fill out the link that we'll be providing at the end of the class.
All right, do 10 more seconds here. All right, I'm going to end the poll. So we have a good mix, but majority have, so that's great. Hopefully we in this presentation can answer some common questions and clear things up for you all. So here at the Fair Housing Center, our mission is to prevent and eliminate illegal housing discrimination, ensure equal housing opportunity, and promote inclusive communities. We achieve our objective through education, outreach, research, and advocacy and enforcement. We were founded in 1980, and we are a private nonprofit organization. We started as a grassroots effort to desegregate the schools and integrate neighborhoods. We cannot provide legal advice. We do not have any attorneys on staff. All information provided is for educational purposes only. And one of our biggest things we like to just kind of think about big picture, about just where you live affects how you live. And so being able to choose freely is really important. And that's why housing choice is really important.
It also helps address kind of the importance of accommodations and modifications, which we're focusing on today specifically. So we'll touch on some other things with fair housing, but really that's our focus. And as I mentioned, there are other fair housing centers across the state, and we'll show a map of kind of the service area, but this information and these links are all in the handouts in the PowerPoint summary as well. So we've got fair housing centers in Kalamazoo, Ypsilanti, and Detroit. And between all of us, we cover the entire state. So hopefully we can connect you if you aren't already connected. However, we're happy to be your first step. And this is the map. We cover the purple counties, but tend to actually end up doing a lot of education in the red counties as well. That Fair Housing Center doesn't provide these types of classes. So we have been able to kind of expand our opportunities to do this education a little bit further. From our perspective, it's all about fair housing protections based on federal, state, and local fair housing laws. We'll also be heavily looking at HUD guidance today, which is used to determine fair housing rights and process fair housing complaints. So we lean very heavily on that and pull from that information ourselves. Just to let you know that fair housing laws extend beyond just the rental transaction. They cover home sales, home loans, homeowners insurance, property insurance, zoning, land use, appraisals, and really any element that's about accessing housing and somewhat maintaining housing is covered under fair housing. These are the other protections. Of course, we're focusing on disability protections today, but you can see, especially if you've been in our classes before, the list and this slide keeps growing. And it's been an active year for adding protections here in the state of Michigan. We now officially, as of February 13th, have sexual orientation and gender identity protected, in addition to whether or not somebody's married and age outside of senior housing. Across the country under the federal list. Oh, sorry, Bree, I was just going to do a quick rundown there. Besides disability, we have race and skin color, national origin, familial status, meaning presence of children under the age of 18, and religion protections. If you have federal funding at your property, that will trigger coverage of additional HUD rules, including the equal access rules. So that is linked there for more information. And then for local, you have to do homework, and we're happy to help you figure out if your communities where you have properties have local fair housing laws. Quite a few of them do these days. And then we've got an update from the Michigan legislature. They passed the Crown Act this past summer, short for Creating a Respectful and Open World for Natural Hair. It went into immediate effect, not like the sexual orientation and gender identity protections, which took about a year to go into effect. For the first time under state civil rights law, which includes fair housing law, we have a definition of race. It was previously undefined. This is the new definition. As you can see, it focuses on traits historically associated with race, including but not limited to hair texture and protective hairstyles such as braids, locks, and twists. Civil rights law also covers employment, education, and public accommodations, as well as housing. And we've seen some issues with cases brought based on protective hairstyles in education and employment more often, but it does apply now to housing. So that's important to be aware of. And as I said, just this is the last day of the month, so I can say this one more time. Just this month, we added sexual orientation and gender identity officially as protected classes. So if you don't already have that language in your policies, it might be a good time to take a look and update any documentation that references protected classes. And so here's our homework for local fair housing laws. We've given you a couple of resources where you can look up codes by village, city, township, etc. 2 different Michigan-based sites. Ann Arbor, Detroit, Grand Rapids, Holland, Kalamazoo, Kentwood, Lansing, Traverse City, Wyoming are just a few of the 40 some odd cities in Michigan that do have additional fair housing protections. Saugatuck, Jackson, Belding, you name it. There are a lot of communities that have additional protections. So it's important to know your list of protected classes, get really familiar with it, because that will help with complying with fair housing laws. Knowing which laws and protected classes are attached to your properties is a first great step for compliance. For our caseload in 2023, we have the largest open caseload in our history. We had a record volume of intakes in 2022, and we're still managing a lot of those cases this past year. We opened 140 more though, and as you can see, we are still seeing disability-based allegations of housing discrimination leading our caseload. We had over 70 cases. A lot of those had to do with accommodations. Another great reason to spend some time focusing on this subtopic. We did also receive allegations of race and/or skin color-based discrimination, and then kind of drop down to smaller numbers of families with children experiencing discrimination, people with alternate sources of income besides employment in certain local cities like Grand Rapids, Wyoming, Kentwood, and Holland, where this protection exists, also filed complaints of discrimination. And then we had a handful of national origin and gender-based cases, and then a small number of marital status, sexual orientation, age, and religion cases in West Michigan. Heavily the caseload related to differences in treatment in the rental transaction. So that's something that we'll be focusing on a lot in our talks. We will also be doing all sorts of other different topics. So take a look at our website. I'll share the link to our training page at some point later in the class, but you can find that online very easily, looking at what that looks like and what people's rights are in rental housing. But over a third of our caseload really was related to failure to accommodate people with disabilities. And then there was a small subset of, I think it was 2% of our caseload was failure to allow for reasonable modifications. These are changes necessary for people with disabilities to fully use and enjoy their housing. So we'll look at those, but you can see there's all kinds of different transactions and behaviors where differences of treatment are alleged and found in our work. And so it's important to understand disability protections, and we start with what does that mean? Who is considered legally a person with a disability? So a lot of you have probably seen this information before, but especially if you're new, it's important to understand that it's broadly defined. It's very well written under civil rights law to be inclusive, to allow for people's individual circumstances and the unique impact that a physical or mental condition can have on each individual to inform the situation. That also can make it very difficult to comply with or understand fair housing laws. It's a broad term. It's physical and mental impairments, one, that connect to or limit or impact a major life activity like sleeping, walking, bathing, breathing, driving, hearing, eating, seeing, going to work, conducting our social life. So there's a condition and it has a major life activity impact. People are also protected if they are regarded to have a disability, or they have a record of having a disability in their past. So it extends a little bit beyond the person. It can cover assumptions, and also it covers people that are associated with people with disabilities. So it's a very, very broad protection. But this is the baseline of helping us figure out whether or not somebody is covered under fair housing laws. Do they have that physical or mental impairment? Does it limit a major life activity? Are they assumed or regarded to be a person with a disability? And as I mentioned, there's two opportunities to work with, and this are both things that are required to consider requests for modifications and accommodations. The question is what's reasonable, and we'll spend a lot of time thinking about that today. But I highly want to encourage you, if you haven't taken a little bit of time, click on these links. And I think we actually even sent the PDF documents out for these joint statements. A lot of the guidance can be very legalese. I consider it, you feel like you need a law degree to read through it and understand it. But these were written in a very user-friendly question and answer format and really help illustrate what's intended behind allowing for accommodations and modifications for people with disabilities. And if you're faced with a request, can help you navigate the process and also figure out what your steps are and what the guidance recommends. So these are really strong resources that I encourage you to take a look at. And I will say too, it's the first thing that I'd say our team looks at too. We can immediately go to, is this a protected class? And then, okay, what does the guidance say? So we recommend that you do the same thing that we do. Are they protected? Okay, if they are, let's look at the right set of guidance. If you're not sure, you can reach out to our education and outreach team and we can help you do some of that assessment. But these types of changes are really critical for safety, for dignity, for quality of life, for aging in place, for allowing families to stay together and have full enjoyment of their property. It can be any sort of housing. It can be an HOA, a homeowners association, condo boards, any sort of connected community, co-ops, rentals, home sales. Everybody is potentially a recipient of accommodations and modifications if you are a housing professional. These pictures here are a nice example of small modifications made to remove two steps. You can kind of see there's a step at the door and a step at the threshold of that porch. And after the construction, it became what we call a 0-step entrance. There were no barriers anymore, which was a huge help to this family who was raising a 12-year-old who largely relied on a large, heavyweight electronic wheelchair to go in and out of these doors. And mom would have to carry him and the chair separately in and out multiple times a day before we were able to advocate and get this modification allowed for. So we'll look at modifications here a little bit in more detail. It can really be any sort of change to an existing premise, whether it's occupied currently or about to be occupied by a person with a disability, in order for them to have that full enjoyment, full access, to be able to prepare meals, to take showers, to come and go from community spaces, and again, get all of the value of the housing that they're paying for. So a couple examples here, ramps to building entrances or directly into unit or home doors themselves, grab bars in showers or bathrooms, swapping out round doorknobs that you kind of grab and twist for lever style, kind of a bar type handle, different stoves with controls on a front panel versus on the back behind the burner that people who are seated in wheelchairs could much more safely use. Installing flashing lights connected to a phone or a doorbell type system, things along those lines are things that you can generally reach out and touch. If you can put your hand on it, it's going to be a modification. This is an example, sorry, our slides are a little bit backwards, of again, proof of what somebody considered an accessible entrance, that second staircase that is shorter on the right-hand side, clearly not accessible. So, these are things that we do still see issues with and can be significant literal barriers for equal housing opportunity. If you do have that federal financial assistance, you are also subject to Section 504 under the 1973 Rehabilitation Act. This converts modifications, or those structural changes that you can reach out and touch, into accommodations for those unique housing providers. So if you work for a HUD subsidized apartment building, the U.S. Department of Agricultural, Rural Housing Developments, others, public housing agencies, public housing commissions, you treat modifications like accommodations, and that switches the responsibility for payment to the housing provider, unless it can be proven to be an undue financial and administrative burden, or it can be proven to be a fundamental alteration of the nature of the housing or the program, and also requires, alternate accommodations to be made. So if you don't know if you have federal financial assistance, it's something to clarify so you know which laws apply to you. Here's a case example from a fellow fair housing center in Michigan. They took a complaint from a gentleman named Daniel Black, a man with dwarfism. He did settle his lawsuit against his apartment complex and the management company after 5 years. He originally requested that his federally subsidized apartment be outfitted with a roll-in shower to accommodate his disability. So this is a 504 covered property. The modification is the responsibility of the housing provider. He asked the management to replace the bathtub, which was becoming increasingly dangerous for him to use. He also was requesting the building install an accessible electric entrance door so that he and other neighboring residents who are seniors and people with disabilities could freely come and go without asking for assistance each time, so that they could come and go from their accessible apartments. This is a photo of Mr. Black posing with a fair housing outreach campaign, talking about fair housing and his experience, and helping raise awareness of his case. So the sides of the tub were 16 inches tall, and the inseam on the inside of his leg was 17 inches tall. So it's very challenging for him to enter his tub and access just being able to shower. The housing provider claimed a roll-in shower would cause structural damage to the building, but never provided any documentation or proof of violations of that, of what code would say. They also never engaged in the interactive process, which is a core component that we will talk about today. Anytime you receive an accommodation or modification request, both parties should engage in what HUD calls an interactive process. Work together to figure out what works based on the unique needs of the individual, the impact of their unique disability or disabilities, and the type of housing. What are we looking at? Concrete, level, drywall. What do we got? The city inspector was able to verify that no structural damage would occur, as did 2 outside contractors. So their defense of saying this would be damaging was not borne out with proof. After receiving no response, and he'd been advocating for quite some time, he did contact that local fair housing center. The center wrote letters, spoke with staff, spoke with the attorney, consulted that local inspector. Each request was delayed and or denied. According to Mr. Black, he was tired of contorting himself to get over the side of the tub. It was dangerous, especially since he had already had 4 back surgeries to relieve spinal pain. He's got extensive metal hardware in his spine that severely limits his mobility. And what he was seeking was not unreasonable. He needed that modification to his ground floor accessible apartment. He wanted what everyone else had, access to bathing and showering facilities. His cooperating attorney was Robin Wagner. Spent a few more weeks attempting to resolve the complaint without litigation. She was following, as always, what we do at fair housing centers is follow the lead of the client and what their wishes are. When they couldn't resolve it, they did file a lawsuit, and it was assigned to Judge Junker. According to the suit, the defendants threatened Mr. Black with eviction in order to intimidate him because he sought to exercise his rights to have modifications made to his bath and shower and to the front door of his apartment building. Eventually, they installed the shower and the electronic entrance door to the building, and the lawsuit was settled for an undisclosed amount. But the takeaway is there is living for 5 years without being able to just undertake daily activities safely, and really having to advocate and push for changes that should have been made, I think, a lot quicker. So quick takeaways: communication and follow through are key for modifications and also accommodations, but staying in communication. It's important to be aware that the impact on the surrounding landscape or the look of things, the aesthetic things, are generally not going to be feasible reasons to deny modification requests. There can be some partnership and conversation about the final look or whatever, but we've had too many modification requests really dismissed out of hand, or, those don't work very well, we're not going to do that for you. That was in response to one of our clients requesting a keypad lock on his door, which have become now very, very common. Would have been much easier for him to utilize. He did a lot of things using a tube that he held in his mouth, and having the keypad would have made coming and going and securing his apartment much easier. He went without locking his door for years because maintenance dismissed his request for that. You can require the changes be made in a workmanlike manner and be up to code. We want them to be safe and professionally done in a way that are safely done so that they can be used without any harm to anyone. If what you're being asked for is found not to be up to code or would be prohibitively expensive, you want to have documentation of that. But you also have to offer alternatives. So again, that interactive process of continuing the conversation. The initial request is not allowed by city code. What do we do next? So the conversation continues. Please use the Q&A feature too for questions, so we make sure to see them and answer them. It's a little bit easier for us to kind of keep them separated if you can.
And we will answer
multitasking. Okay.
And we will answer more specific questions at the end, just because we want to get through the content. But if there's any clarifying questions, we will ask that throughout, or answer that, sorry.
And then I think we have some steps to offer as a good resource to look back to. Some questions that are important to help make an assessment of a modification is: who's going to use it? Is it the individual resident? Is it within their four walls? Or is it to a public space where the public and other residents come and go? Is it where, at the front door to the leasing office? Those sorts of questions help understand which laws apply, who might be responsible, who might have to pay. Of course, you want to do homework regarding any code compliance. And then, part of that is, okay, do we need any plans or drawings or schematics? Can we observe that this is a person with a disability? Can we observe that this is necessary? I think our case with Mr. Black, you could see that he was utilizing 2 canes and relied on them to walk. So there's a mobility impairment there. So that's a case where documentation would not have been necessary. We will talk more about that. Another big question is who pays? And that depends on which laws are triggered and how the property is funded. Generally, if it's private housing for the individual's sole use, they would pay for those changes. If it's federally funded housing, generally the housing provider is going to pay. If it's in a joint space, so to speak, then it may be a joint co-sharing of those costs. But these are all things that have to be evaluated on a case-by-case basis and looked at, as a unique request each time. You can also have a conversation about what happens to the modifications when the tenant moves out or no longer is there to need them. That's all outlined in the guidance. And we also have a step-by-step guidebook to help. It includes a sample response form and ways to help document all the work that you do as you're considering these types of requests. So for the accommodation side, these are automatically going to be the responsibility of the housing provider or housing professional. Why? Well, we're asking for changes in your rules, your policies, your procedures, your services. So it's going to change the nature of what you do every day. If those are necessary changes needed, again, to have equal access and enjoyment of housing by a person with a disability. So here's examples of an accessible or handicap space with an aisle, curb cut, nice signage, accessible parking on the left, and a selection of assistance animal dogs on the right. So Remember, people can ask for any sort of accommodation or modification. Our job is to welcome it and document it. Not everything is reasonable, and maybe not everything is fitting under what is considered a modification or accommodation. But we do want to welcome them, do the homework, and figure it out. Examples of accommodation requests allowing for overnight caregivers. This was a couple of situations where we saw prohibitions against any overnight guests. When an overnight caregiver is needed, that would be a reasonable accommodation. Assistance animals, despite a no pets policy. Assigning an accessible parking space, despite having a first come, first served parking policy. Accepting rent based on the arrival date of disability income without late fees is a very common one. Releasing someone from their lease penalty free, not charging them the balance of the rent if the housing cannot be made or modified to meet their needs. That is through no fault of their own, and we kind of consider that the final accommodation. We can't make the changes necessary. The housing no longer works for them. They don't have equal access, full enjoyment. They shouldn't be required to stay there. Transfers to different floors or different units. And then something important to consider, thinking about effectively communicating with people with disabilities. One example would be providing an American Sign Language interpreter. We did provide some resources, but we'll highlight a couple of the effective best practices to think about if you do receive a request for an interpreter for someone who uses sign language. Again, it's important to recognize the ask, document everything that's disclosed to you, and refer to your reasonable accommodation policies. Generally, a good idea to follow the lead of the person who is making a request. A request for ASL interpretation for in-person service should be evaluated under reasonable accommodations when they are requested. For a tour, for completing an application or signing a lease, when the communication is lengthy, legal, important. We recommend knowing how to call and arrange an ASL interpreter ahead of time, just having those resources, do that research ahead of time so that you can respond effectively when it's requested of you. If the first option or the request doesn't work as far as timings or a lengthy delay, then you must offer or consider alternatives and be open to different ways of communicating so that the process of the housing search can continue. One option is video relay interpreting, or VRI. It can work well for unexpected and quick meetings, but we need to be aware that VRI does not work for everyone universally, and many people within the deaf and hard of hearing community prefer live interpretation over VRI. It can happen too often where people are kind of forced or stuck using VRI, and if it doesn't work for them, it's not effective communication. The communication is failing. The individuals who are deaf or hard of hearing themselves can use 711 service. Anyone who is not deaf or hard of hearing, they will not continue the call. They will hang up on you. They are focusing on serving people who are deaf and hard of hearing only. Others use the teletypewriter or TTY or telephone telecommunications relay services operators. So if you have a call from an operator, you continue and you speak as though you are having a call from an applicant as you normally would. A couple other quick best practices. Keep line of sight free for information and visuals. So be very aware of spatial awareness and making sure that individuals can see you, you can see them. Look directly at the person you're communicating with, not at the interpreter. It may feel weird or rude not to acknowledge the interpreter, but you speak directly to the person you are communicating with, the applicant or the resident, because that is the conversation that is occurring. You are conversing with them. Use I and you, avoid third party like ask her or tell him. Again, it's that direct communication with the individual. You don't need to speak louder or shout. You may be asked to, but don't assume that that's necessary. You also want to speak at a reasonable pace and allow time for people to receive and absorb all of the information. We included some West Michigan-based resources here that we have engaged with. I'm sure there are others out there, but wanted to share those resources as available to our service area. And then I think we also have other resources that we just wanted to have available to you. These blue links should click and open a web page from your handouts. Disability Network Michigan has a whole map of Michigan with contact information of different disability advocacy centers that cover different counties across the state. So you can kind of find your local disability advocacy group there. You can also contact state departments that we've got listed here, and also Association for Blind and Visually Impaired is here in West Michigan. And again, Deaf and Hard of Hearing Services, great resources there. So not a bad idea to familiarize yourself and be prepared ahead of time, especially if you're frontline service. Case example here out of California. This was a HUD case. They announced a conciliation agreement with Shadowbrook Gardens. This required them to pay $4,000 to the resident and $7,000 to the local Fair Housing Center Project Sentinel, who assisted the client in filing the complaint. The tenant had requested to have a live-in aid and a key to a locked gate that was very close to her unit that would make it easier for her to come and go. This tenant does have a mobility impairment. Both the property manager and owner asked intrusive questions about her disability beyond what was necessary. They challenged even whether or not she had a disability. They asserted that the housing development was for individuals who could live independently. So they were inferring that she was no longer a fit there, and they denied her requests. They deny having discriminated against the tenant, but they did agree to enter into this conciliation agreement. We see that a lot. In addition to the monetary relief, which was $205,000 to cover damages and attorney's fees, the agreement allowed for the owner to keep the gate either unlocked or provide the tenant with the key as requested. So one of the two. It also requires the owner and property manager to allow that live-in caregiver and then get fair housing training and implement a reasonable accommodation policy that is in compliance with the Fair Housing Act, or as we often abbreviate it, FHA or FH Act. I think we have another case example here quickly before we move to assistance animals. This is a reasonable accommodation for a transfer handled by the Louisiana Fair Housing Action Center. We call them LAFAC. They settled a federal lawsuit against a Covington apartment complex. The settlement also includes training, which is something we always want to see. Changes in policy, we want to see that too. So, the goal is, what can we do to make sure this doesn't keep happening? What processes and practices can we put in place to ensure that this is hopefully the last time this happens? So this was the case that had $205,000 in damages. The other one was the $7,000 and $4,000. My apologies. This was a applicant requesting, a current resident requesting to move to a first floor apartment back in 2017. She had surgery. Afterwards, she was relying on the use of a wheelchair. Her apartment was on the second floor and only accessible by stairs. She made 3 additional requests over the course of a year, and all requests were denied. So this put her in a really terrible position. She was left crawling down the stairs, or she would call 911 anytime she needed to go outside, take the trash out, pick up her mail, drop off her rent, go to church, get groceries, visit friends, have a life, go to doctor's appointments. The fire district responded to over 100 calls to her apartment. And in fact, the fire chief was begging staff at the apartment complex to move her to the first floor apartment. Her requests were responded to by placing her at the bottom of the wait list, even though at least one ground floor unit was vacant at the time. So really a huge impact on her day-to-day quality of life. Using services that could have been utilized in emergencies and elsewhere. Only after the lawsuit was filed did they finally offer her a ground floor unit. So the settlement was really an important step to ensure that people with disabilities are prioritized for those units that are designed to meet Americans with Disabilities or ADA standards. It covered 9 apartment complexes across Southeast Louisiana. So that's a great one case example that has a ripple effect across a lot of housing, hundreds of units. So we also have some steps to refer back to and keep handy if you do receive a accommodation request. Let's start with the basics. What is your existing policy or rule say? What are we asking for the changes to? What is that standard, and how does this request differ? Kind of getting that clarified. Do we need documentation? Are they a person with an observable disability? Do you already have information about their disability? They have a disability. You want to take that into account as you process these requests. You also want to have good understanding on all parties' sides of when and how the policy or service goes into effect or gets changed. Make sure all staff that need to know are made aware, document everything. So you can see this also takes homework, and we can help by offering all of the tools that we've mentioned, and we'll review again at the end of our time today. So now we get to assistance animals, and I will turn it over to Debris to take the lead. We're going to start with a poll question, a couple questions with some commonly asked questions that we get at the Fair Housing Center.
Yes, thank you, Liz. So our first poll, or second poll, I should say. Let me launch it here. Our first question is, a person is limited to one assistance animal for disability-related needs, true or false? Number two, you cannot charge a deposit or upfront cleaning fee for an assistance animal, true or false? Again, these questions are anonymous, and we don't use them as any way to judge your knowledge.
There's no grading. We don't have
Yeah.
time for grading.
So I will give everyone another minute here to answer the questions. About 10 more seconds here. All right, put in any last answers. All right. Sharing those results. And the majority of you did choose false for the first one, which is correct. A person is not limited. Sorry, I wanted to rephrase that. Is not limited to one assistance animal. And we will kind of dive into that question, or that poll question, and a little bit into the training. So if you have any further questions after we've covered that, please let us know. You cannot charge a deposit or upfront cleaning fee for an assistance animal, and 83% of you said true, and that is correct. And we will also talk about that a little bit more. So if you have any questions about those, we will cover them, and then you can ask any clarifying questions after.
I think it's helpful to equate an assistance animal with somebody asking to use, a cane or using a wheelchair. They're a tool for a person with a disability. So I don't think we would have the inclination to charge a cleaning fee for a person who's using a wheelchair up front. So that's, hopefully will help kind of with framing the understanding of these are not pets, and they are tools necessary for people with disabilities.
Thanks, Liz.
Mhm.
So looking at the 2020 assistance animal guidance, there are HUD calls out two types of assistance animals. So assistance animals is the umbrella term, and then beneath that are service animals, which we know are often dogs and are often trained. And then the second one, HUD refers as support animals, and those are trained or untrained animals that do work, perform tasks, provide assistance, and or provide therapeutic emotional support for individuals with disabilities. The assistance animal guidance does walk through a series of questions, and we will walk through some of those today. And, it starts off with an assessment of whether the animal's dog is an individually trained service animal, and that kind of gives you that answer if they are a service animal or a support animal. Again, we'll walk through that. And then it also incorporates information that you may already have known about a disability or the disability related need. So these are things to keep in mind if you know the person has a disability or a disability related need when we talk about documentation further on in the training. So the first part is service animals. And this only applies to dogs. And this only applies if they are readily apparent, if it is readily apparent that the dog is trained to do work or perform tasks for the person with a disability. There's really no further inquiry needed. Kind of those questions that you're limited to. If it's not readily apparent, is the animal required because of a disability, and what work or task has the animal been trained to perform? So this is if the animal is a service animal and the disability is not readily apparent. You can ask these two questions. If the answer to either of those is no or none, then it does not qualify as a service animal, and it jumps to part 2, which is support animals, which is on page 7 through 8. It is readily apparent when the dog is guiding an individual who is blind or has low vision. If the dog is pulling a wheelchair, if the dog is providing assistance with stability or balance to the individual with an observable mobility disability. Uh, Otherwise, um, emotional support, comfort, well-being, companionship are not specific works or tasks for purposes under the ADA, which is the public accommodation. Then moving on to support animals. For housing providers, they must comply with the Fair Housing Act for access, and then they must consider the reasonable accommodation request, even if the resident made the request after bringing the animal into the housing. HUD does leave that open in the guidance. And then the last thing is it must be considered, or the RA request must be considered even after the housing provider seeks to terminate the resident's lease or tenancy because of the animal's presence. So as soon as they bring up that it's a reasonable accommodation request, an emotional service animal, it kind of triggers the interactive process as we talk about. And so kind of everything, you kind of have to wait for that documentation and kind of go kind of through the process then. Assessing for support animals. This is on page 9 through 11, and there is 5 questions that we'll kind of go over. So the first question is, does the person have an observable disability, or does the housing provider already have the information giving them reason to believe that the person has a disability? So that first question is targeting the, do you have information already that this is a person with a disability? And we'll go through these questions. We'll talk about what that looks like. Number 6, has the person requesting the accommodation provided information that reasonably supports that the person seeking the accommodation has a disability? So have they already provided other information? Do you already know, or have they provided additional documentation? Has the person requesting the accommodation provided information which reasonably supports that the animal does work, performs tasks, provides assistance, and or provides therapeutic emotional support with respect to the person's or the individual's disability? So looking at that first question, number 5, on page 9, what do you already know? What can we observe? What information do we already have? Have they already talked about their disability with you or other staff? Do they have other reasonable accommodation or modification requests that have already been made? Are they on disability related income? So these are things that would help you know if they are already considered a person with a disability. Some other information that you may already have, if you have a determination from a federal, state, or local agency. If the person is a recipient of disability benefits or Social Security Disability Income, or SSDI. If they are the little video screen is blocking some of the text.
Oh,
If they are on Medicare or supplemental security income for a person under age 65, if they are on veterans disability benefits, if they're receiving services from a vocational rehabilitation agency or any other kind of disability benefits from another federal, state, or local agency. Additionally, you may have housing assistance or a housing voucher received because of a disability. Um, and then you may have information from a healthcare professional that, when we talk about documentation, you might already have information from a healthcare professional that states that they are a person with a disability. And the HUD guidance does say a healthcare professional, and then they list some options, but it's including but not limited to physician, optometrist, psychiatrist, psychologist, a physician's assistant, nurse practitioner, or nurse. Um, if yes, there is an observable disability, or we already have information that gives us a reason to believe that they are a disability, then you'll skip to question 7. If no, if they don't have a disability that's observed, or we have no disability information prior, then we'll continue to question 6, which is next. That's on page 10. Has the person requesting the reasonable accommodation provided information that reasonably supports that they have a disability? If yes, then proceed to 7. If no, they have to provide a reasonable opportunity. You must provide a reasonable opportunity for them to get that information to you. And then if there is no disability at all present, they can't give you any information that they are a person with a disability, then they do not have a right to a reasonable accommodation. However, if they're requesting it and then they don't have the documentation, you still have to give them time to get that information to you. Question 7, which is on page 11, has the person requesting the RA provided information which reasonably supports that the animal does work, performs tasks, provides assistance or therapeutic emotional support with respect to the individual's disability. So are they showing that they have a disability related need for this animal? If yes, then you can move on to the next section, which covers types of animals. If no, again, you have to allow them time to get you that documentation. You can also refer them to the guidance in HUD on how documentation looks. We also have uh, resources and tools that we have provided that you are welcome to provide to your tenants that are looking to get documentation or don't understand the process. You can give them all this documentation that we've provided you. So looking at types of animals. Any domesticated animals that's traditionally kept in the home for pleasure rather than commercial purposes are allowed. So dogs, cats, small birds, rabbits, hamsters, rodents, turtles. However, reptiles, other than turtles, barnyard animals, monkeys, kangaroos, other non-domesticated animals are not considered common household animals, and those are considered unique animals, and they require more documentation or more information on why they are specifically needed for a disability-related need. So some examples would be, a monkey has the dexterity to open up pill bottles. That would be a reason to allow a monkey as an assistance animal. Or other, they have to have that reason for that specific animal, that it can't be their disability related need cannot be helped with another type of animal, a domestic animal. Additionally, the guidance calls out that no fees or deposits pet rules, no limits on breeds or sizes of support animals or dogs for service animals are allowed. However, you may charge for damage if it is your usual practice. So at the end, if you are assessing for security, for the security deposit and damage, if that's your normal practice, you can charge for any damage that the animal has been done, but you cannot charge any fees up front. You may refuse a reasonable accommodation if the specific animal poses a direct threat that cannot be eliminated or reduced to an acceptable level through different actions. So if there is documented threats happening or uh, issues happening with a assistance animal, and the individual cannot do anything to maintain or control them, you can refuse them. So, but you have to walk through that process with them and make sure that they understand that if they're, if they can put a muzzle on, if they can, crate it, things like that. If those things can be done, then you cannot refuse it. However, if they can't do any of those actions, then there is the ability to refuse. Another thing is the animal is the person's or the tenant's responsibility to feed, maintain care of, and control. They can do this on their own. However, there could be some assistance from other families, friends, volunteers, things like that, depending on the person's disability. And for that last one, we will talk about a sample assistance animal guide that can kind of help hold the tenants accountable. As I talked about, this is called when somebody asks about a reasonable accommodation, triggers an interactive process. So, as a housing provider, you must engage in a good faith dialogue with the requester. You cannot insist on specific types of evidence um, um, of information. You cannot ask about like the diagnosis or severity details of the diagnosis or severity of the disability or any medical records. Those cannot be required. You may not require a healthcare professional to use a specific form, even HUD's document. However, you can provide it as an ability to educate them, but it's important to make them aware that you're not requiring it. um, Additionally, if the original request is denied, you must discuss or offer alternative accommodations. So if that accommodation cannot be met, then you have to offer additional or alternate accommodations. Some fair housing risk that we have seen is requiring the use of specific forms. Time limits. There is about a 10-day period, which HUD calls out as reasonable. However, it's really important just to ensure you are keeping connected with the individual. If it's something's taking a lot longer, just letting them know, oh, I'm working on this, just keeping them updated. Again, this is an interactive process and there should be ongoing communication. Some other risk is using subjective language about the disability, assuming the person's trying to avoid pet rules and deposits, requesting information on just a lot more information on treatments, other attempted treatments, kind of getting into the weeds of why this is necessary. That opens you up for some fair housing risk. Asking for an agreement to additional charges, again, on the front end. And then asking the healthcare professional about their willingness to testify in court or other proceedings. So these would all open you up to some fair housing risk if these were found in the process. Housing providers, some best practices may find it helpful to consistently maintain a list of reasonable accommodation requests, including assistance animals. Generally, 10 days of receiving the documentation, you should make a determination. And then we have seen kind of on the tenant end, kind of that as well, allowing them time to get that documentation, checking in with them, making sure, again, that should be a really, I'm going to keep saying
Interactive
it,
process.
interactive process.
Over and over and over again. And it depends. I mean, we know there's a backlog with accessing your healthcare providers. So, we reasonable isn't defined necessarily, but it's, I think that communication can really be beneficial.
Yep. And then a big thing, really just separate that assistance animals are not pets. As Liz talked about, kind of think of this as a tool for this person with a disability to be able to access this housing, enjoy this housing. Um, and think of it as a wheelchair, as a walker. They are separate from pets, and as going forward, you should be um, communicating that this is an assistance animal and not a pet when you are communicating with the tenant. um, Conditions and restrictions that housing providers applied to pets may not be applied to assistance animals, kind of going on that same line there. And then again, well, we kind of discussed this a couple times throughout this presentation, but you can charge for damages if it is your usual practice to charge tenants for damages. So if
Just not before they occur.
yes,
Actual
and,
damage has to have occurred.
you can't, just charge damages for the person with a disability. If that isn't your usual practice, you can't just start charging damages for only the people with assistance animals. We do have an assistance animal resource guide, which is linked in this presentation, but also was provided in the handouts email. Again, if you did not receive that, please let us know and we can send you an email, forward that on.
Make sure you give us your email, especially sometimes we get registrations with typos and we can't contact you. So it's helpful if you email us.
Going over that resource guide, it's really meant for anyone, regardless if they are a person with a disability making the request, if they are a housing provider processing one, or just an advocate looking for more. We wrote this in a way that is for everyone, and it's transparent and it gives the information for both sides of the spectrum. It includes additionally a sample support letter, again, which you can provide to folks, but again, make sure that you're not saying that this is required. It's just an example to help people understand what one looks like. We did also provide a fact sheet in the email supporting requests for assistance animals, which can be provided to that can be provided to healthcare professionals if they are looking to write letters. Oftentimes, healthcare professionals don't really know what is needed in the letter. So having that fact sheet is just a way to help them understand what the letter should look like, again, but not requiring.
Yeah, most
And then,
doctors, nurses, they're not experts in fair housing and civil rights law. So that
yeah.
fact sheet is a really great tool that Bree gave out to help them understand what this is all about.
Yeah. And then it also includes a sample assistance animal policy, which we will be talking about. We definitely consider adopting an assistance animal policy. It helps address behavior and care. Um, Especially, this is really important when you also allow pets. This shows that there's a separation between the two. However, but it allows you to address, the control of the animal, the noise and behavior, compliance with existing laws, leashing if it doesn't interfere with the function of the assistance animal, and then the cleanliness, cleaning up after it. Um, it and as you can see, we did provide that, so you can kind of see the language that we have. We've taken directly from HUD's guidance. The policy, again, can help with education, but again, accountability. It sets forth expectations between both you and the tenant. It documents that you accept assistance animals. The one that we provided can be customized with the company name. We do recommend that it's signed and copied for all parties. It would be something that you could include with the lease. And then it would be, part of the lease.
We do see people sometimes say, oh, we just use our pet addendum for these. And I strongly encourage taking the time to consider adopting a separate assistance animal policy. Pet addendums often include language about fees and include requirements that cannot be applied to assistance animals. So while I see that it might feel appealing to kind of apply that, it's best to really separate it out. And I think it's a great way to help endorse that you know what assistance animals are related to disability rights.
And then we are going to go into a case now. So there was a case in Minnesota.
Mhm.
I think it's Minnesota.
Winona, Minnesota. It
Yeah.
rhymes.
Oh, yes, it does. It says Winona. So there was this was a case with HUD that was charged for violating the Fair Housing Act by refusing to allow a tenant to live with her assistance animal. The complaint alleges that the landlord denied the applicant's reasonable accommodation request to live with her assistance animal and even rescinded the offer of a lease when her disability-related need was presented. The applicant supported her reasonable accommodation request with a letter from her therapist, which provided all the information the landlord needed. And the applicant even included information from HUD right on to the reasonable accommodation request. However, the landlord still refused it and told her to look elsewhere. He then told her he would return her security deposit and would rescind the lease offer. His response to her disclosure of her disability related need was to suggest that she get rid of the cat or rehome it until he adopted a pet policy. Um, upon receiving the verification letter and the HUD information, he emailed back and said, "There are other places. Don't worry. I can refund your deposit." The applicant was then forced to seek another place to live under a tight time deadline. And the complaint actually suffered actual damages, including but not limited to physical and emotional distress, inconvenience, frustration, and loss of a housing opportunity. And then, so now we are going to move on to supporting documentation.
So
I
this
am
is
go
beyond just assistance animals, right, Bree? So we're talking about accommodations and modifications.
It'll be mostly on assistance animals.
Okay.
Yes. So we have another poll here, which I lost my polls. 1 second. Sorry about that. So this is the last poll of the training. And the question is, when someone with a disability asks for a reasonable accommodation for an assistance animal, you can always ask for proof of disability. I will give everyone about a minute and a half here to answer that.
Maybe a little less. I'm watching the clock and we want to keep
Mm,
moving. We have a fabulous
Sorry.
FAQ section coming up that Bree put together that I think will answer some of the questions that we are seeing. We do see them in the Q&A. Thank you. I don't see the poll screen either. So the poll function in Zoom has been really questionable. I think we can just go ahead and answer the question since it's not operating. Sorry about that. Yeah, I think the keyword here is always.
Yes. So the answer is false. Because again, as we talked about, if they have a visible disability, or you already have information about their disability, they don't need to provide proof of that. Sorry, my screen froze there for a second. Again, I'm gonna just refer to these questions. When you get documentation, it is really important to review these questions and does your documentation answer these questions? If not, then you can ask for more information. Ask that, let them know that you don't have the answers to these questions within their documentation. Um, in the assistance animal guidance, supporting documentation consists of information from a licensed healthcare professional. Again, they leave that pretty broad. They do cover, I will say this HUD guidance was written or released a few weeks before COVID. Since then, a lot of things have changed, especially with telemedicine. So there isn't more information than really this on documentation from the internet. So documentation from the internet really should confirm that it is a person, uh, they're a person with a disability and they have disability related need for the animal, and that the provider has personal knowledge of that individual and the person's disability. If you, again, do not have good documentation or there's no documentation, we always recommend educating the requester and inviting them to provide further information. You can provide these resources to them You can also refer them to us. And we are happy to talk about what documentation looks like. And then again, the determination must be made on a case-by-case basis. Every case will not look the same. Every situation will not look the same. So again, those should be looked at a case-by-case basis. Again, if you deny the request, you must offer an alternative to their accommodation. And this goes for all accommodations and modifications. If any requests for modifications or accommodations are denied, you must also offer an alternative. So now we're moving into the frequently asked questions portion of the training. One that we get a lot is if a tenant or resident requests permission to have more than one assistance animal. In HUD's guidance, there is no limit. However, on page 4, it does lay out that most requests involve one animal. Sometimes there is more than one. Some examples could be that a person has a disability-related need for both animals, or there's 2 people living together and they both have a disability-related need for a separate assistance animal. So really, when there are multiple animals being requested, the things to think about, or the things that wouldn't be needed by the person, is they need to substantiate that they have a need for more than one. Do they do different tasks, unrelated tasks? Is the benefit the animals provide only achieved through having multiple animals? I know there was a case with multiple ducks, and it was the ability to count so many ducks. But that needs to be laid out in the documentation or in whatever information you receive. What is the disability related need for both pets or multiple animals?
So if I request for cat A and cat B, the substantiating information, the third-party verification should help establish either that it's multiple pets that are necessary, or that cat A alleviates these symptoms and cat B alleviates those symptoms. So I'm seeing a couple questions in the chat and the Q&A about, what if it's one person or 4 cats? So that may be a question of, what does local law say? There are some communities with restrictions. That person would need to go talk to the local government to address those. But on the front end, I just want to encourage you to welcome the request and let them know that you'll need to do homework to look into it. You can also use our information to educate people. If you get an unusual request, I saw somebody say, "Oh my gosh, a kangaroo." Well, there was a case with a kangaroo at one point back in the day. So, we want to encourage you to be welcoming, and then, spend time looking into each individual request, because as you know, and I'm seeing in these comments, that they're complicated.
Yeah, and Liz touched on the last point there. Again, check with local governments, and then if they are exceeding local government laws, they would have to then go to the local government to get a reasonable accommodation.
Mhm.
Or request a reasonable accommodation. Can I deny the assistance animal due to insurance? Assistance animals, and this is from HUD, assistance animals cannot be denied due to housing insurance policy that has a restriction or prohibition against certain breeds, sizes, or number of animals. If the insurance carrier would cancel or substantially increase your costs or adversely change the policy terms because of the certain animal or breed, this may impose an undue financial and administrative burden on you. However, you still need to verify that there is not comparable insurance available. So if your insurance is laying out things, you have to show it could be denied. However, you'd have to show that there isn't other insurance that you could get. We also encourage you to educate insurance companies about the Fair Housing Act regarding assistance animals, and document this. It's for this specifically. It's really important to document your insurance policy, any communication with your insurance policy about this if you get a request. Can I require the owner to get pet insurance or animal insurance? Housing providers cannot require persons with disabilities to pay extra fees or deposits, and this would be considered that. However, if you require renter's insurance for all your tenants, there would be no fair housing risk. If you only require the people with disabilities to get renter's insurance, that would again create some fair housing risk, because that would be differential treatment based on disability, and it would also be considered an extra fee. So if your policy across the board is renter's insurance, you can require the person with assistance animal to get it. However, you cannot require specific animal or pet insurance. Can I charge a cleaning fee or for any damage caused by the assistance animal? It depends. You may not charge an upfront fee. However, as HUD calls out, you may charge a tenant for damage an assistance animal causes if it's your usual practice. You can deduct that from the security deposit again if that's your usual practice. The if damage is found during the residency or after move out, they can be assessed for that. If the damage is above the cost of normal wear and tear, you can also be assessed for those costs as well. What if the person requesting an assistance animal provides me with an ID, won't engage in the process, or tells me I can't ask them any other questions? Feel free to refer them to us. Our enforcement coordinators are very happy to provide them with the information needed. If you are really trying your best to educate them, and they are just resistant to your information, and they're not providing you adequate documentation, please have them call us. We are really happy to educate people on the assistance animal HUD guidance and the laws that pertain to them. So now we're gonna go switch gears and then talk about processing reasonable accommodation and reasonable modification requests. So again, with reasonable accommodations and modifications, it's an interactive process. You're entitled to obtain information that is necessary to evaluate if it's requested, if they are a person with a disability, and if they have a disability related need, especially if the disability is not obvious or known and the disability related need is not readily apparent or otherwise known. So if you do not have the information, you can ask for it. But if you do have the information, we don't recommend asking for it. With the interactive process, a housing provider may not ordinarily inquire about the nature and severity of the individual's disability. Really, the only information that you need is if they are a person with a disability and they have a disability-related need. And then we have some documents, which we have provided. We have provided actually all three of these documents, but we have other publications and information on our website at that link. The guidebook in the middle is for housing professionals to assess reasonable accommodations and modifications. It kind of walks you through that process, what it looks like. And then the other one that we have provided to complement it is for folks requesting, so housing consumers requesting reasonable accommodations and modifications. And so you are welcome to provide that document to any tenants that are requesting it, if they have questions about the process or what it should look like. Within our guidebook, we do have a sample response form that housing providers can utilize to kind of assess the request and provide your response. Approving it, and then it's effective immediately. We will provide it by this date. If you need to request additional documentation, or if you to make the change requested, they have to do, you have to do additional additional work. And so this is just another way to document that the process is happening, that you've looked into it, that you are working on it. Again, documentation is really important when processing with anything, but both processing reasonable accommodation and modification requests. Uh, there's another part of the form, we've not approved your request because there's additional information needed. And then another portion for offering an alternative. And then denying the request, why you would deny it. You weren't able to verify that they were a person with a disability. You were unable to demonstrate that the accommodation or modification is needed because of a disability, or because it would cause a financial or undue administrative financial or administrative burden on your operations, and providing that information to them. Um, for Approving and denying requests depends on circumstances, and is again on a case-by-case basis. Any request you would get, as Liz has talked about, based on your questions, some of these can be very complicated. So ensuring you have all the information needed, and that you are documenting every step taken, any communication with the tenant or resident, is documented. And then again, you guys know this, but we just want to make sure that all information should be kept confidential. Persons with disabilities typically have the most accurate knowledge about the functional limitation posed by their disability. So it could be a conversation. We cannot provide X accommodation because it's a financial administrative burden. Talk with them. What would be another option? Again, they are the best person to know what they need and what they would need for them to live enjoyably and happily in their home. And then moving forward, some resources and links. Focus on the Fair Housing Act. Do your homework, and then we have some tools provided, and then we provided a lot of resources in the emails. Those are all of our assistance animal, all of our reasonable accommodation, and all of our reasonable modification information. Again, that you can also use our website. You can search up those documents if you lose the email. And then I also wanted to provide some MSHDA links. There is the MSHDA Fair Housing page. There is their policy statement, compliance for rental housing, information for landlords, LIHTC compliance, and the Housing Choice Voucher Program. So those links are linked in the handouts that we sent you, the presentation that we sent you. Again, we have lots of tools and resources, and we have a Fair Housing Laws page, a publications page. We have fact sheets on everything, separate from disability related information. We have information on occupancy, on zoning, on families with children. We have everything. And if there's something that you are interested in and we don't have, let us know and we can look into it. And it could be something that we could create depending on funding. And I think that concludes it. I know Liz is working on some questions diligently. Evaluations should have opened in your browser. This is where you will also do your attendance verification. Please complete this by tomorrow at 5 p.m. If they are not completed by this time, we cannot guarantee that we can send you certificates, just because we really need that documentation to show that you were here. That link will also be provided in the chat.
I just put it in the chat right now.
Thank you. And we will mail certificates. You will not receive the certificate after completing the SurveyMonkey link. We will mail them, and they will be coming in the coming weeks. I would say, you know, in a month from now, if you haven't seen one, you can reach out to us. But with these trainings, we have almost 300 people on today, 260 people. So that is a lot of certificates to print. Um, Additionally, we will be, save the date, we will be having our annual Fair Housing Workshop series on Thursday, April 18th at the DeVos Place. It's our first in-person since before COVID. And registration is not open. However, it will be opening in the coming weeks. We will have some workshops on sales, on lending, and then on communities and how communities can be opening and welcoming and equitable in terms of fair housing. All right. Well, thank you. And then I think
We'll try to take a couple of questions here. I tried to get to as many as I could. Bree, is that okay?
yeah,
Yeah,
uh,
okay. Yeah.
I'm gonna blow my
So,
nose really quick though.
okay, yes, yeah. Struggling through the seasonal cold and what a champion. So, a couple questions about multiple animals. You know, we really encourage that housing providers allow people with disabilities to have the same amenities as individuals without disabilities. So if they're allowed pets, as long as there's no overcrowding or their animal law violation, it's worth considering what's reasonable and allowing for an additional assistance animal. But again, that's going to be based on unique circumstances, and each request like that needs to be evaluated on a case by case basis. Is it acceptable to require an animal to be leashed as opposed to be tied out on a lead so they're able to clean up after the animal immediately? You know, again, this is something that could change based on the function of the animal and how the animal is used to meet the needs of a person with a disability. So leashing generally, especially if it's required by existing law, is okay. However, the animal may be a seizure response animal or be trained to interact with someone who's having anxiety or panic attacks. And leashes may actually interfere with how the animals go about performing their duties. So again, case by case, but generally, yes, you can refer to our sample assistance animals to address you know, keeping the area clean and ensuring that the animal is cleaned up after so that it's not producing health and safety violations. And, you know, having an assistance animal is not a hall pass for bad behavior and disturbing others. You know, they have to comply with other provisions of the lease, like noise provisions, and be a good neighbor. So that's why we really strongly recommend a separate assistance animal policy that can help with accountability. I've had multiple kind of questions about this. So I want to say, you know, once you have an assistance animal policy in place, we would recommend that you would kind of look to enact or enforce that policy in a way that you would enforce other policies. Do you offer 3 strikes? Do you write a letter and inform them they're in violation and ask them to come into compliance? Do you do that 2 or 3 times? And we really encourage you to work with the individual, document everything so that you can show, listen, we had 3 meetings about cleaning up after this assistance animal and things haven't been improving. It's interfering with health and safety of other neighbors. We've got pictures, we've got documentation, because I want you to be able to show, if you're ever challenged by a civil rights investigator, all of the actions that you took and the documentation that you have to show that you did everything in your power to really accommodate this individual. And if the animal is aggressive or, you know, is snapping at people, you know, maintenance can't enter without the animal being crated. You know, those are sorts of things that also need to be evaluated, but, you know, do so very carefully. So we appreciate those concerns and all of these good questions. I wanted to address somebody saying, you know, we give a form to someone because we are federally funded, so we automatically give them a form. You can give that form as an option, but the HUD guidance says you really can't force someone to fill it out. So if that doctor has already provided a letter that answers questions 5, 6, and 7, then, you know, you have the information that you need, and requiring that form could be a violation of the HUD guidance. So a family who's requesting 5 animals, 1 for each family member, that would be something of weighing the reasonableness, looking at what's allowable under local law, what type of animals they are, what sort of documentation there is. You know, we really want to see verification from individuals who are healthcare providers who have an ongoing relationship with the individual. This can happen across state lines. We've been asking for additional clarity. Michigan looked at passing state law on this and did not take action. So we recommend that you really default to the HUD guidance, because that is our current guidance here in Michigan. Those of you in other states may have to do other homework, and we can look for local fair housing centers for you from the National Fair Housing Alliance. Another common question is, what if we have a letter that's over a year old? I encourage caution with collecting additional disability related information once an accommodation has been granted. If the letter specifically says this is something that's going to be reevaluated as part of ongoing treatment, that may be something you can talk to your attorney about. But generally, we really discourage annually collecting additional disability related information until we get better guidance on what that looks like. A lot of the websites that kind of quote unquote sell those letters and certificates do put those annual expirations on there because they're looking to have that fee renewed. So when we see that type of documentation, what we would recommend is educate your tenant, educate your applicant, send them to the Fair Housing Center, send them to our website so that they understand that these are federal laws and federal rights. And we encourage you to educate them and invite them to provide more documentation. And then you can really show that you've taken sincere action, meaningful action to meet their needs. And I know it's frustrating if somebody says, well, I would like this pet and I'm just going to go get it registered. Well, you can document that they said it's a pet and that they said we're going to go get it registered. And then it's a judgment call as to whether or not you feel like you could substantiate what occurred and whether you would be able to defend yourself in terms of responding to a civil rights complaint with those types of observations. I'm hopefully keeping up with a lot of the questions. Bree, what are you seeing that I'm missing?
Somebody followed up on the one that's the form again, requiring a person to have a form filled out is called out in the HUD guidance as something that is not best practice. It can open up to fair housing risk if you are requiring certain forms to be filled out.
Okay, and then briefly, I think I put this in a chat or a Q&A. HUD's addressed potential concerns from other tenants. What if I have other residents who are allergic to animals or they're afraid of animals or uncomfortable living near an assistance animal? And HUD's official response has been, you may try to address these concerns, but you may not limit the fair housing rights of a person with a disability who needs that assistance animal. So it's about trying to strike a balance. If the other person is severely allergic to the point of anaphylactic reaction or, trouble breathing being around a rabbit, for example, that is someone who also has a disability and would also need to be accommodated. So again, it's kind of gathering information and kind of reviewing what's possible based on the unique circumstances, the style of housing, how it's set up and things like that. So really good questions out there. I think if you are not planning to stay on, you've completed the training, thank you. You're welcome to log off. We may take a couple more moments here to make sure we've addressed as many questions as possible. We knew we'd get a lot and we were trying to forecast them and answer them in our slides. So hopefully we did. A common question about is, what rights does an emotional support animal have to be in the spaces? You certainly don't have to allow an animal in kitchens where food is prepared, but you want to look at what is the function of the assistance animal in terms of generally they should be allowed to go where people are allowed to go. What if there's a denial? Great questions here. What if there's no disability or disability related need? Then there's no need to accommodate if there's no disability and disability related need. Someone else asked about, what are alternatives? And that depends. Again, we have to further our interactive process and have conversation with individuals to find out what else would be reasonable. For those of you that do have pet policies and allow animals on your property, it might be very challenging to show that having an assistance animal while you're allowing other animals also for companionship and pleasure and pets. It might be a real hardship to show that assistance animals would be unreasonable. So that's another point I wanted to be sure to make.
I'm also seeing another one about, where did it go? If they don't notify you that they have one until they get a lease violation. HUD says that they can request assistance animals at any point, even if they've already gotten the dog or gotten the pet, or gotten the animal.
Yeah, so that's explicitly lined up in the HUD guidance. And so our preference is they get permission, right, Bree, ahead of time. But we know that's not what happens. And you said pause the lease violation, pause the eviction.